When police show up to search a home, you expect them to show a search warrant authorizing the raid, but that may not be the case in San Diego. Welcome back. I'm Jesse Pagan.
I'm Carlo Cicchetto. Here, San Diego police have been handing homeowners redacted warrants with the address of the home to be searched blocked out. CBS 8's David Gofferson talked to a legal expert who says the use of redacted search warrants in the field is unconstitutional.
When San Diego police officers and FBI agents raided people's homes last month as part of Operation Mic Drop, they were looking for people with arrest warrants, like Greg Otis's nephew, who lives in the family's home in Mountain View.
Did they search your house?
Yeah. Officers handcuffed Otis and his wife, but they did not find their nephew, and they did not show the couple a search warrant.
My wife's 65 and I'm 68. You know, what the hell we gonna do?
At a news conference days later announcing the indictment of 22 people, Deputy District Attorney Miriam Hemming told me officers do not have to show the homeowner a copy of the search warrant when the homes are raided. Is there a requirement that you give them a warrant that specifies what to be seized and the location to be searched?
No.
But at other homes raided by police during the same operation, officers did leave a copy of the search warrant when the relatives demanded to see the paperwork. Here it is, a redacted search warrant with the address to be searched and items to be seized X'd out and sealed by a judge.
My understanding is that those warrants were provided to the individuals that were at that location, albeit in a sealed fashion, and that is entirely lawful and consistent with what the judge's orders allow.
I showed veteran civil rights attorney Gene Iredale a copy of the redacted search warrant. He said it makes no sense because the address of the home, which is redacted in the search warrant, is already being raided by the police.
We have the San Diego Police Department and the task forces saying, warrants? We don't need to show you no stinking warrants. We're the police.
While there is no California law requiring a copy of the search warrant be given to the homeowner, Iredale says people have a constitutional right to see the unredacted warrant authorizing officers to go inside a particular home.
It ensures that the homeowner knows you can't resist. You're required to permit the search to take place because this is a lawful search with a specific piece of property to be searched and certain things to be searched for, and it's been approved by a judge.
The prosecutor told me officers have a copy of the unredacted warrant so they know what address to search.
Law enforcement is responsible in every instance, not just on this case, but any other, in ensuring that the target of the search warrant is in fact the location that's specified within the warrant itself.
But for Iredale, that's not enough.
The homeowner's ability to verify that this is in fact a regular and proper procedure has been completely taken away. Why? Because the police are acting with a certain arrogance and a certain idea that, well, just trust us. We wouldn't do anything wrong.
And he says a judge sealing the warrant beforehand does not trump the Fourth Amendment.
The name of the place to be searched and the persons or things to be seized are not the only things that are X'd out here. They've attempted to obliterate part of our Constitution. And it's important that we say you can't X that out.
The DA's office emailed me a statement, and we're going to post that at cbs8.com. But it basically says the redactions are legal, and they were approved by a judge. And if you think it's unconstitutional, you can go to court and challenge it. Well, as it turns out, that's exactly what attorney Eugene Iredale is planning on doing now, as he was recently retained by a woman whose house was raided by police, and she was handed a search warrant almost completely X'd out. At the downtown courthouse, David Gofferson, CBS 8.